today as well is to keep to time. From the program, I think what we have next is the introduction of the speakers, letting us know a little bit about the speakers, and then I think the first lecture will start. Am I correct, Kike? I don't want to. Am I correct?
I think.
Yes. Okay. And yes. Okay. So Kike, after John, Kike, you take over.
Oh, Kike, no, Kike, you go ahead. I'll just introduce the talk. So Kike, if you'd like to speak, please do.
Okay. I'll introduce the team from Center for Law and Business. We already have Mr. Dapoyomi, who is the Managing Director of Center for Law and Business, and myself, I'm Kike Lomo Wishason, and I'm the Business Development Manager at Center for Law and Business. What we do at Center for Law and Business is simple. We're a one-stop hub for everything education. We provide access to world-class education to students in Nigeria, young and mature students, and we have quite a wide range of intellectual products on offering. One of those products is the SOAS University of London MSc in Finance and Financial Law, MSc in International Business Administration, MSc in Public Policy Management and Public Finance, I think. And of course, we also offer teaching support to students of University of London who want to study in Nigeria for the University of London degree. Under our professional programs are the ACC, Association of Chartered Certified Accountants, and CIPM, which is Chartered Institute of Personnel Management for HR practitioners in Nigeria. And we also offer seminars and workshops and symposiums, one of which is this that we are doing in collaboration with SOAS University of London today. We're delighted to have everyone here join us at this inaugural edition. We believe there are going to be many, many subsequent ones, and they are going to find them very interesting and beneficial. Thank you very much.
Thanks, Kike. So, hi everyone, I'm John Whitaker. I'm one of the partnerships managers here at SOAS, and I work closely with our friends and colleagues at Centre for Law and Business, and obviously with our CEFIMS department here at SOAS. It's really great to join you all today, and thank you all for coming along. We're really pleased to launch this partnership with this lecture series, and we look forward to many more over the coming months and years as well. So thank you all for joining this inaugural lecture today. It's my job just to introduce you to each of our speakers, our two speakers today from SOAS. You've already actually met the first one, Alberto Asqua, Dr. Alberto Asqua, who's told you a little bit about him. But these two talks today will really give you I think a flavour and a taste of the areas that our finance and management degrees and programmes cover. But it'll also give you I think a sense of the way SOAS approaches these themes and these topics, and perhaps the lens through which we view these areas at SOAS. So you'll really get a good kind of sense into the unique approach that we take. And I think you'll find these two talks very interesting, very relevant to today. So without further ado, I'm going to welcome, and I hope you'll join me in welcoming Dr. Alberto Asqua, who will be talking about the regulation of emerging technologies. Alberto, I'll hand over to you.
Thank you, John, and I hope you can hear me and see some slides which I'm sharing now on the screen. As I anticipated earlier, I work at SOAS as a senior lecturer in public policy and management at SOAS University of London. I'm interested in public sector management, but specifically public policy, public administration, public financial management. It's an interest that I always had since my first career. I used to be a chartered accountant back in Italy, where I'm from originally, before embarking to academia, starting from an MSc and PhD at London School of Economics, and then I've been working at SOAS for about 9 years so far. I should say, in addition to the programs we teach, to the research we do, I'm also very pleased occasionally to do within SOAS some executive education programs. And what comes to my mind is also some visitors we had from Nigeria, from NIMASA, the Nigerian Maritime Administration and Safety Agency, who spent a couple of weeks in London a couple of years ago. That's what I mentioned just as an instance of a sort of very stimulating collaborations we have with many partners on many occasions. In this particular speech, what I'm going to do is to share with you some thoughts and current research on a fairly particular area. It's a kind of a niche area, but I'm becoming more and more passionate about it because I believe it's going to have a great impact in the lives of everyone in the future. As you see from the title, I'm concerned with the governance and regulation of contemporary technologies, but specifically the one around the genome editing. It's part of a broader research interest I have towards emerging technologies generally, something like the blockchain and crypto assets, or nanotechnologies, or artificial intelligence as applied to self-autonomous vehicles, for instance. These technologies, they do have a very number of intriguing features, but they do also pose a number of challenges. Here I collect some bits of news from the past, which provide some instances of the sort of issues which are there for policymakers and regulators. The risk of errors in artificial intelligence systems leading to crashes in cars, for instance, the opening up of new opportunities for frauds and scams, like opportunities to steal cryptocurrency value, or unknown dangers which are posed to health, to the environment, like for example, the use of novel substances, like those coming from nanoparticles. Within the range of emerging technologies, the range of problems from emerging technologies, there are a number of those of especially focused concern for social scientists generally, anyone interested in public policy, around basically how should these emerging technologies be regulated. It's a very tricky issue because most of the time, to some extent, even scientists and then also policymakers, regulators, they may not have quite a deep grasp of what is it precisely to be regulated. And so there are really conceptual issues of definitions at the very end. Then there is the issue of fully understanding what sort of dangers or hazards are actually posed, and many of them are just discovered along the way as applications are developed, and we just try and test what can be done with that. Questions arise concerning who should be regulated, specifically developers of new technologies, of new systems, of products or services which are launched into the environment, and eventually what kind of regulatory tools should be applied. So my perspective, as you see, is purely the one of a scholar in public policy and regulatory policy, specifically looking at the emergence of new technologies and posing such questions. I should confess, in the past, I've always been interested in regulatory issues, but originally from infrastructure industries, things like electricity and water. They are not less important, of course, than emerging technologies for quality of life of many individuals. But emerging technologies, as you see from the news, they are kind of more and more pervasive in the way in which we carry out our lives and the kind of products and services we can expect in the future. I started by focusing on a fairly specific sort of technology, which is the one about genome editing. And specifically, I refer to a technique which is originally called the clustered regularly interspaced short palindromic repeats. But fortunately, everyone really knows about it through the acronym, which is just a CRISPR. The research into this area dates back to the 80s and 90s in Japan, in Spain. Then also industry paid attention to this technique. It basically very loosely originates from the discovery of certain particular features of the DNA of bacteria, which was later discovered originate from a kind of immune system of the bacteria against viruses who could attack it. And the point was that the DNA of the bacteria retained like a fingerprint, in a sense, of the viruses which had attacked the bacteria in the past. And so the question was, how was it possible that the DNA was modified? And eventually, especially in 2012, scientists came to discover the molecule which enable the possibility to edit the DNA. By editing the DNA, I literally mean the possibility to change any letter, which, as you know, A, C, G, D indicates for basic types of molecule, which for part of the bigger molecule of the DNA. In the past, a sort of genetic engineering has been around for decades, but that was quite different. In the past, there could be kind of a rough techniques of bombarding the DNA by means of X-rays, for instance, and kind of to wish that a desired modification to the DNA would be brought about, possibly even by fusing or merging together DNA material from different organisms. By genetic editing, we mean something different with respect to genetic engineering, because we really mean the possibility to change any single letter, in principle, of a DNA sequence. The discovery came kind of in a contemporary fashion from the side of various teams of researchers, especially one which was jointly based in California and in Sweden, and another one based at the Broad Institute. In less than 10 years, this technique became like a groundbreaking discovery to allow the modification of a DNA in a way which is much more efficient, effective, and especially economic with respect to genetic engineering we had in the past. And last year, this culminated into the award of a Nobel Prize to two leading researchers of the 2012 discovery. It is no surprise, possibly, that together with the scientific discovery also comes commercial applications. And here in the slide, I also mentioned some among the main companies based in the US and in Europe. Part of them are funded by the same scientists who had discovered the CRISPR technique about 10 years ago, and which have embarked themselves into research, especially in healthcare, but also in other areas. This is also related, incidentally, to some ongoing controversies concerning patents and conflicts between groups of researchers who claimed to be the very first one to discover technique and the range of application of this technique. Potential applications of CRISPR started to appear in publications and also on the press. We have instances like, for example, possibility to find out a treatment for diseases from HIV/AIDS, for instance, or for example, to apply this technique to change the DNA of mosquitoes as a way to eradicate invasive species, which could be carrier of illnesses. This technique, CRISPR, holds some potentials for applications in other fields, like for instance in agriculture. And the other scenario could be to genetically engineer or edit, actually, more productive or more resistant crops, which could result in dramatic competitive advantage to those firms who could be the first one to patent, for instance, a new DNA for plants. But possibly the most controversial aspect became apparent a few years ago. In late 2018, there was the second international conference on genome editing based in Hong Kong, and the Chinese researcher stepped on the stage announcing that he had performed a CRISPR modification of the DNA of two babies which had been recently born. There were various justifications and reasons for carrying out this intervention behind. Apparently, this was intended to make these babies genetically resistant to catch AIDS illness, which apparently the parents of these babies had. But the basic point is that this researcher and researching team seem to have crossed a red line, because all over the world, by and large, genetic modification of human DNA, especially of human embryos, is largely banned. In a few countries like the UK, it is allowed for research purposes, provided the embryos are terminated within 14 days before their full development, and definitely before anything can be implanted to be grown as a proper fetus. And therefore the idea that this technique could be deliberately used in order to make a modification of a DNA of humans, that was something kind of unprecedented in history. And this triggered, of course, catalyzed a lot of attention eventually towards this technique, and posing bigger questions concerning what can be done, what should be done, what can be allowed to be done by means of this technique. Here I borrow a map taken from a publication from Science of a few years ago concerning the extent to which countries differ and the way in which they do allow experimentation with and applications of genome editing, and other jurisdictions which are relatively more restricted. Like any map, I believe this one is kind of inaccurate, incomplete, possibly outdated, but generally it gives the idea that by and large many countries in the world did not even pose the issue of how to regulate such a new technology which just popped up in less than 10 years ago. A number of jurisdictions are relatively restrictive by providing explicit limits to the use of genetic modification, specifically in embryos, as I said earlier, but also potentially in other areas. There is an evident concern that the uncontrolled use of techniques of genome modification could bring about unforeseen negative effects to humans, to the environment. Like, for instance, the release into the environment of a species whose DNA has been modified. We may not really fully know how this is going to impact the ecosystems within a country, or even possibly other countries in the world. So what I did together with colleagues is to embark into research in this area. And we started, for instance, by surveying the way in which genome editing is regulated in some among the main countries or areas of economic activity in the world. Just to share a few examples, in the US, genetic engineering had been already subjected by a system of regulation. It's a so-called coordinated framework dating back to the 1980s. And after the emergence of a genome editing technique, a number of initiatives, especially from the side of scientists, were carried on in order to stimulate an intervention from the side of the government. And actually, we had a couple of initiatives from the side of both Obama and Trump presidents to input, to provide the directives to the agencies of the coordinated framework, which basically were along the lines to try and open up ways to accommodate the new technique within the existing regulatory system, but definitely to encourage innovation, and so to provide that bit of flexibility to look at new products, so products coming out of genome editing within the existing system of regulation. But the world does provide a lot of variety. As we look at the European Union, for instance, we find a fairly much more restrictive or conservative approach. This may date back already to about 20 years ago, when the so-called GMO directive, so a directive about the genetically modified organism, provided a framework, a legal framework, which was relatively restrictive to the use and commercialization of organism, which had been the result of genetic modifications, according especially to the previous genetic engineering techniques. So basically, practically, genetically modified food is banned from the European Union, although as understood, some part could be tolerated as to whether it is feed for animals rather than food for humans. The point is, this directive originated out of a previous set of techniques of genetic engineering. Genome editing, it's another game, and for quite some years there was the push towards European Union institutions to regulate what to do with the new emerging technologies. And here, by and large, EU institutions remained relatively static. There was kind of a regulatory inertia until it was another actor within the regulatory system, the European Court of Justice, to step in. Prompted by a case which came out in France concerning the introduction of this technique for some crops. Eventually, a case was brought to the attention of the European Court of Justice, and despite some initial potential opening, which was apparent, eventually the ECJ ruled that new genome editing products would be regulated according to the existing GMO directive framework. This triggered quite a number of controversies, especially from the side of industry within European Union, who claimed, but here it's a completely different game, you know. Basically, the kind of genetic modification we can get out of a CRISPR technique is very targeted. It's not anything with a side uncontrolled effect as we might have expected out of the previous techniques. And so there is still at present a debate within European Union about having European Union institutions, the Parliament, the Commission, to provide a new regulatory framework which would apply to the emerging genome editing technique. But for the time being, the outcome of this European Court of Justice ruling is the one to crystallize basically the situation with the existing regulatory framework, and also to discourage practically a number of R&D projects and development around this area. But this is just a couple of jurisdictions in the world, because as we went on in another research which is currently in press, we also went on to survey genome regulation in the UK, in Australia, in Canada, in Japan, in China. And basically we realized the variety of regulatory tools which are deployed or could be potentially deployed in order to cope with the genome editing. A very traditional way to classify regulatory tools of government is the one to distinguish between nodality tools, which is basically to handle information, authority tools, treasure tools, which have to do with money, and organization tools, the government to set up government agencies to carry on projects directly. And if we think about the business model we can develop around an emerging technology like genome editing, we may think about an input side, like we need capital, we need know-how, an output side, we need to deliver, to license out, to market the products or services out of applications of the new technology, and we have the proper business development, especially R&D investment. Well, any of these parts of a business model could be regulated, subjected to regulation, depending on different sets of tools. So if you think like at least a monitoring effort from the side of the government to require companies to disclose what kind of genetic materials they buy, what kind of investments they make, and of course what kind of products or services they offer to the market, possibly with a labeling requirement and so on. But other set of tools could be about authority, like for instance requiring company to apply for a permit before doing any research at all, or even commercializing any result of this technology. The government could use money as a tool. They could subsidize, if they like, research in this area in many forms, or even the commercialization of products. Or governments could step in by setting up government research centers, for instance, and fund PhD programs or research programs, and eventually, of course, also hold ownership, patenting the results of this technology. It should be clear this technology can have quite a number of applications. It's a kind of a dual technology, as it is called sometimes, which means there can be applications in business, in public services, including also the domain of the military. Out of this technology, it could come, for instance, the possibility to engineer or to design, if you like, bacteria or viruses, which could be in principle used for as a bioweapons. And so, if not for the sake of developing such tools, at least to know what could be developed and to prepare the means to counteract this sort of development seems to be something sensible we may expect the governments to do. Of course, I just stop here for the sake of time. I'm very happy to share this couple of publications to anyone if you're really interested. Because otherwise, I come to the conclusion around this topic, just to leave a few open issues, which are for me kind of lines of research to undertake, but possibly something which can be of interest for many of us. So really understanding what can be the effects of this genome editing technique for healthcare, like holding the promise of treatment of diseases from cancer to many others, increasing productivity of farming, increasing productivity of various sorts of agrobusiness, for instance, but also thinking about the implications for international trade as one crop becomes much more productive than others. This may shift, the balance also of competitiveness of different companies and countries in the global trade of commodities, for instance. And so questions are, what kind of regulatory tools would be more appropriate? And if we think about some sensitive areas like human embryos, for instance, or crop bacteria or viruses, should governments go for a full ban of the use of this technology, or to leave it unrestrained? Or what kind of tools of regulation should be applied? Another interesting issue is the one about global coordination. Should country governments coordinate to regulate this technology or not? If they do not do it, it is quite evident that for startups or multinationals, they could forum shop and to search for the most convenient, advantageous regulatory regime, one country or another one, where to set up their labs and then eventually to develop products. And so any country which is more restrictive or conservative could lose in that technology race, in a sense, with respect to other countries which would be more tolerant or even encouraging more research in this area. And then a very final question would be, where is genome editing in the public policy debate? Because given the importance of such technology, maybe we may expect or we may wish to hear more about it out of the public debate in the media or in our elected representative bodies to tackle these questions and to see what can be done in the future. Very final slide is also, as you can see, I tend to be even passionate about this topic, and therefore within a personal website, I amassed there a number of resources, links, which you may find it interesting just as a starting point to read more about genome editing, especially, of course, with respect to regulation and governance. As a social scientist, I can't step into the details of the technicalities of the chemistry and biology around all these, but definitely as a social scientist, there is quite a lot of interest around that. Well, that's all from my side, and I see, yes, I'm within the time which has been allocated, and being punctual for an Italian is something amazing to obtain. So I stop here. Thank you very much, everyone, for your attention.
Thank you, Alberto. That was a quick but fascinating look at the history and potential kind of future uses of genome editing technology. There, something that's totally new to me. So that was really interesting. Thank you, Alberto. We'll move on to the second and final speaker for today. We've got Senior Lecturer and Program Director at CEFIMS, Dr. Richard Alexander, who will take a look at the sometimes illegal activities of transnational organizations and corporations, and how we might target and address these issues. So Richard, I will hand over to you.
Thank you, John, and thank you to Director Oyumi and to kick in the team at the Center for Law and Business for putting together this quarterly lecture. And before I start, I'd like to offer a particular welcome. It's a great pleasure to see one of my former students in the audience, dialing in from Singapore. So this is a truly global event, which is great to see. So without further ado, right. So I'm going to be talking this afternoon on the use of proceeds of crime measures to target the transnational activities of corporations. And I want to say at the outset, I'm not just talking about the big multinational enterprises. We know that multinational enterprises or multinational corporations, as they're sometimes called, we know that they bring with them a range of legal and regulatory issues, but I'm not just talking about these huge corporations, the General Electric, the Ford, the Shell Oil, the HSBC. When I say transnational activities of corporations, I mean any activities of a business entity. It needn't be a corporation, although in practice it typically is. In practice it's typically a commercial company that engages in activities outside its own jurisdiction. The fact is that corporations frequently do business across borders. Now, a lot of the time, there's nothing wrong with that. A lot of the time, that's fine, that's good, we would encourage that. But some corporations, unfortunately, take advantage of laxer laws, more lenient laws. I'll come on to those in a moment. Or, let's be honest, laxer enforcement of laws. There are certain jurisdictions that have great laws on the statute book, but when it comes to how they're enforced, that can be an issue. It might be in some jurisdictions the way that you get around legal or regulatory issues that the company finds inconvenient is they arrange to take the relevant official out to a very nice lunch. But I'm not just talking about corruption here. In some jurisdictions, enforcement is lax simply because it is poorly resourced. So, for example, in India, the lead office of the Indian police in combating the trafficking of women into the sex trade is located in Kolkata, and it consists of 3 officers. And their principal responsibility is for the state of West Bengal, but they're the leading anti-sex trafficking office of the Indian police for the entire country. They have 3 officers. And the fact is there are corporations that are aware of this, and so they take aware of laxer laws or at least laxer enforcement of laws to engage in behavior abroad, to engage in behavior outside their home jurisdiction that would be illegal if they did it at home. And so what I'm going to be looking at this afternoon is how can we use proceeds of crime measures to target this kind of behavior? How can we use existing measures to, frankly, make it less profitable for companies to behave like this? So what do I mean by proceeds of crime measures? Well, what I call proceeds of crime measures cover 3 main areas: anti-money laundering laws, criminal asset recovery, and civil asset recovery. So, money laundering, first of all. Of course, money laundering does not literally take place the way it's displayed in that little picture, and in fact it never has, but it makes the point. So money laundering is a transaction involving the proceeds of a criminal offense. Now, traditionally, if you look at what the Financial Action Task Force and various law enforcement bodies at international and national level say, when we look at them and we say, what is money laundering? They say, undertaking various transactions involving the proceeds of a criminal offense in order to disguise the true origin and in order to make it appear that the property has an origin that is more legal, more legitimate than it actually is. But actually, if you look at what the laws state, concealment is merely one aspect of money laundering. Money laundering is basically a transaction, in any transaction involving the proceeds of a criminal offense where you know, or in some jurisdictions like my own, suspect that the property does not actually have a legitimate origin. It is not always necessary to show that the intention behind the transaction was to conceal the origin. If you handle the proceeds of crime, that's money laundering. And crucially, this includes, I'm getting ahead of myself. Crucially, this includes the proceeds of an act committed abroad, which would have been a crime had it been committed in the home jurisdiction of the defendant. Now, these acts committed abroad, which would have been a crime if they'd been committed at home, they fall into two categories. Certain acts under the criminal laws of the home jurisdiction, certain acts are a crime are a crime in and of themselves, even if you commit them in a foreign jurisdiction. Now, the most commonly discussed example is overseas corruption. So, if I am an English company and I bribe a government official in, let us say, Senegal, in order to secure a commercial contract, then whether I bribe them in the UK, in Senegal, or somewhere else doesn't matter. Bribing a foreign public official is a crime in and of itself, regardless of where you commit it. But corruption is an only example. This reminds us of what often goes under the name of hospitality in large parts of Southeast Asia. And the reason I decided to choose Southeast Asia, of course, the sex trade isn't confined to Southeast Asia, but the definition of a minor, the international laws take a particularly dim view of those that profit from sex trafficking of minors, of children. But what do we mean by a child? In the UK, any person under the age of 18 is a child for the purposes of our sex trafficking laws. However, in Cambodia, the age limit is 16. So a bar in Cambodia that employs 16 or 17-year-old girls to provide services that go beyond serving food and drink. And the fact is that in many resort areas in Cambodia, as elsewhere in Southeast Asia, that's exactly what the bar girls are for. In Cambodia, if she's 16 or 17, that's perfectly legal. However, under UK law, if a British national is involved in running that bar, then they can commit a substantive crime under UK law. And therefore, the proceeds of the running the bar will themselves be the proceeds of crime. And under the law of certain jurisdictions, for the purpose, it doesn't actually matter whether the act was illegal in the jurisdiction where it was committed. But not just then. Sometimes and often, this is certainly true of English law. Our criminal laws do not have extraterritorial effect. So if you commit the act outside your own jurisdiction, then the predicate act itself is not a crime. However, the proceeds of that act, try and get rid of that. Thank you. Right. However, the proceeds of the act can still be criminal. So what am I talking about? Well, the fact is that certain jurisdictions have stricter or laxer environmental protection laws than others. Here we see corporate activity that is clearly causing severe pollution, but that pollution, the failure to filter the chimneys, the act of simply dumping toxic commercial waste wherever is convenient, might not actually be a crime in the jurisdiction where the factory or whatever is located. However, if you pumped unfiltered smoke into the atmosphere in the UK, or if you simply dumped the waste from your factory just into the countryside in your home jurisdiction, that would be a crime, and therefore the proceeds that you make, the proceeds that you make from these breaches of environmental protection laws can be viewed as the proceeds of crime. Now, before I go on, some of you may be thinking, well, hold on a minute. Hold on a minute. These factories, they don't actually make money from polluting the environment. So let's take a Nigerian example. Let's take the oil spills in the Niger Delta. Now there are those who would say that these oil companies, yes, their activities cause significant side effects in terms of polluting the areas around the oil extraction facilities, but what they actually do, what they make their money from, is extracting oil, and that's perfectly legal. However, increasingly, it's now recognized if you break the law in order to cut your costs, and therefore you boost your profits, those extra profits that you make as a result of illegal cost cutting can themselves be viewed as the proceeds of crime. We continue. Now, how far do the anti-money laundering laws actually reach when we talk about going overseas? Well, in international standards, the Financial Action Task Force recommendations, the UN Convention on Transnational Organized Crime, standards like that now require states to prohibit the laundering of overseas crimes, of acts committed overseas, which would have been a crime had they been committed at home. international standards now require states to prohibit the laundering of overseas crimes as well as the laundering of crimes committed in your own jurisdiction. At least, and this is what the standards say, at least as a minimum, where the act was also a crime in the jurisdiction where it was committed. Which raises the question, well, what happens if it wasn't actually a crime in the place where it was committed? What about if the jurisdiction where the act took place legally permitted it? Well, it's up to states to decide whether to require double criminality, whether to say this will only apply, will only regard this as money laundering, if the act that gave rise to the property was illegal in the place where it's committed, as well as here. Now, the United Kingdom does not require double criminality for the purpose of its money laundering laws. I mean, technically we do. However, the double criminality requirement is so limited as to be pretty much meaningless when we're talking about serious overseas illegal activity. In the UK, double criminality applies if the crime carries a maximum sentence of no more than 1 year in prison. Anything more serious than that, we don't bother about double criminality. Uganda, and I decided when I was preparing this presentation, I decided I'm not going to tell a Nigerian audience what the laws of Nigeria are. So I thought, let's look at some other African jurisdictions. So Uganda does not require double criminality. However, the United States, the European Union, and Kenya all do require it. They all say for our money laundering laws will only cover the proceeds of acts that were illegal in the place where you committed them, as well as in our own jurisdiction. Moving on, we're short of time. Our criminal asset recovery goes by various names depending on which jurisdiction you're talking about. And the way it works is that following the conviction of a defendant for a criminal offense, the proceeds of that crime can be seized as an additional measure, and that's possible against companies as well as individuals. And a number of corporations in the UK have found that out the hard way. But it requires the defendant to be convicted of a criminal offense, but not necessarily for the original predicate crime, especially if the offense itself, under the laws of jurisdiction A, doesn't cover acts committed abroad. Instead, a conviction for money laundering can be followed by criminal asset recovery. And this is where I want to finish on civil recovery. Now, this I would suggest is the most interesting, the most effective means of going after this kind of property. Civil recovery, it's a civil measure as it sounds, and it's what lawyers call in rem. It targets the property, not the holder. It doesn't require anybody to be convicted of a criminal offense. It certainly doesn't require it even to be alleged that the holder of the property committed any crime. Simple proof that the property is derived from a criminal act. Okay, again, does it matter whether the act that gave rise to the property was a crime in the place where it was committed? Now, if you look in the UK, if you look at the United States, if you look at Kenya, yes, it does. Civil recovery is only possible where the act that produced the property was a crime in the country, in the jurisdiction where the act took place. South Africa, however, and Uganda say no. If property is derived from an act committed abroad that would have been a crime had you committed it here, then that property is liable to civil recovery. We don't care whether or not it was a crime in the place where you committed it. So to finish on the stroke of 355, I would suggest that the wider approach of, for example, South Africa and Uganda would enable effective action against the proceeds of crime committed cross-border, committed in other jurisdictions. And as I said, that includes where the costs to a business are reduced through committing environmental crimes, breach of health and safety laws, etc. Overseas misconduct can, and I would suggest should, be made not to pay. Thank you.
Thank you, Richard. Another really interesting topic there to have a little quick dive into. Yeah, thank you so much, Richard, for that presentation. I think I'm handing over to Kike.
Thank you very much to both Doctors Richard, Alexander, and Alberto Asquer. Thank you very much for those insightful presentations. So, well, we're now going into the question and answer session now. I would like to take questions from the audience. A question has already been sent in for Dr. Asquer. Was sent in by Israel Usman. I'll take that, but before I do that, I'd like to make a quick announcement, please. Well, I appreciate if you could send in your questions in the chat box so we can take everything together at this Q&A session. And if you have comments as well, not just questions, if you have any comments or contribution also, could you state that? And if you want to be seen or heard, you're sure that you have a quiet background anyway, you can please indicate by raising your hand, by doing a wave on Zoom, would allow you. So I'll take the question from Israel Usman. It says, thanks, Dr. Alberto. About 20 years ago, I took interest in regulation of technologies, so it was interesting to listen to your insights. I have two questions. In your view, what kind of data retention and regulation can help regulatory oversight in regard to this topic? For example, research data, test data, etc. And the second question, it says, while regulating companies and individuals is difficult enough, how about regulations of rogue countries? What do you suggest? So over to you, Alberto.
Well, thank you, and thank you very much, Israel, for the questions. Very stimulating. I'd love to hear what you think about them as well. But just a few thoughts that you triggered to my mind. The first one concerning data. Data evidence of the effects of technology, I believe they become crucial, especially in the stage where we do not really fully anticipate what can be the effects and side effects of applications of these technologies. That's possibly why I mentioned earlier, I believe an important role could be played by government agencies, including universities within the public sector, to carry out the research in order to provide evidence, first-hand evidence of the effects of such technologies. Alongside the public sector, however, we may expect business entities, however, to undertake their own research, and so therefore to develop proprietary data they may be quite jealous about because of commercial confidentiality and value. A plausible model could be the one like similar to drugs, which is before, in any case, any application is any product would be launched into the market to provide the requirement, enough documentation and evidence of the test of this product is provided to regulatory agencies so that they can scrutinize, review, and eventually approve the release of a genetically modified organism into the environment to be used for any industrial, agriculture, or healthcare use. There could be other means, of course, to overcome the information asymmetry towards what the business may know, and we do not know about the use of these applications. A scenario could be the one of engaging with them by forms of public-private partnerships, which sometimes they may be beneficial also for the business sector in terms, for instance, of mitigating or sharing the risk which goes together with investment into these technologies. And so in a sense, the public sector could have a larger shoulders to stand the risk of failure of R&D projects, but on the other hand, public sector would be more informed about what can be done with these technologies and what are the effects. On the other hand, the question is very interesting because some of these technologies like blockchain or genome editing, they open up what has been called like a democratization of science, in the sense that the investment, upfront investment, which is required in order to undertake development around these technologies is relatively modest. So in a sense, nowadays, if I invest enough time and effort into studying computer science, I may gain enough skills to become a hacker myself. Or online, I believe it is still possible to purchase CRISPR kits from the US, which in principle would enable anyone to set up a small CRISPR lab in the kitchen. And this opens up ways to develop applications in a very fragmented, in a very decentralized way, which of course may not be fully captured by any sort of regulatory oversight. On the other hand, I believe in history, a lot of innovations, applications of innovations eventually came to use together with some forms of regulation, so that in any country nowadays, I can't just jump into a car and drive it without a driving license. So we may expect that a certain form of a certification, if you like, before being authorized in a sense to use certain kind of dangerous technologies could be also one of the regimes we may contemplate. Of course, to get it implemented, it could be quite another game. Also, the second question is very stimulating, the one concerning regulation of rogue countries, which I believe is more generally about their conduct, not just concerning dangerous technologies they can use. My rough understanding of a rogue country, starting from this point, is the one where we may have an elite which strives to keep power, typically in non-democratic means. And we call it a rogue country, especially because they do pose threats to other countries, could be over nuclear, bioweapon, or cyber attack sorts. And how to tackle them, how to regulate them. I believe in the medium long term, the pace of technology innovation does help, in the sense that other countries who are more resourceful can invest more in technology and innovation, may eventually come out with more updated technologies, which are a way to cope and to tame the threats of old, obsolete technologies other countries may have, which may find it hard to develop precisely because of their rogue state, which makes them kind of a pariah, isolated outside of the international community of the flows of capital and know-how. But then, of course, I believe there are also more immediate concerns about how to cope with such countries in the short term. Possibly an immediate response could be a confrontational one, the system of inspections, sanctions we may expect to be carried out. These may work, although possibly I would expect it could be beneficial to be a bit more strategic or Machiavellian, if you like, so that to try and better understand what is in the interest of the ruling elite of these countries, and to kind of offer some way to compromise in between some at least apparent support to the elite from the side of the international community, together with more and more disclosure from their side about what they do or intend to do, or the capabilities they have or try to develop. Well, I know all this sounds very abstract, but I can feel to get into more details without eroding more time from other questions.
Okay, thank you very much, Dr. Asker. I hope that answered your question, Usman. We don't seem to have questions from members of the audience, and I'm wondering why. Is it that the session has been so explicit and holistic and all-encompassing? We have a few kind comments saying thank you, well done, this is really needed at these times of financial insecurities in the world. I guess that's addressing Richard's presentation on money laundering. If someone says, nice insight on money laundering and genome editing. Thank you very much. thank you for this event. I truly enjoyed such great speakers. So well done. It's been such a pleasant time. Okay, thank you. So it seems we only have nice comments, but no questions. That's welcome also. Thank you very much, everyone. Thank you. This has been insightful. I'll tell you, personally, I'm hearing about genome editing for the first time. So yes, it's been insightful, and it's been a learning experience for me personally, and I believe it's the same experience for every member of the audience here as well.
Looks like we might have one question.
Okay, just a minute, John. Please take the poll. The poll is running. We're trying to get your feedback from members of the audience if to help us improve on this program. This is the inaugural edition of this quarterly lecture series, and would like to know what you think about it and how you think we can improve, for future programs. Thank you very much. Please take the poll. It won't take more than a minute, I promise. Thank you. John, please, over to you.
Sorry, Kike, for interrupting it. It was just we had. There looked like there was another question, perhaps in the chat that maybe
that just came
to address quickly. That just came in. Maybe Richard could.
Okay.
Yeah. I was curious what the position on money laundering is in Nigeria. Are we enforcing over all proceeds of crime wherever committed? I took a decision that I was not going to seek to tell a Nigerian audience what the Nigerian provisions are, and therefore, unfortunately, the flip side of that is that I didn't look to see what the Nigerian anti-money laundering laws say on that. I don't know whether Director Dapo would know the answer to that, or if any of the other participants might know.
Okay, Mr. Yomi, are you there? Okay.
Yes, I'm here. The Nigerian laundry law, everybody knows about it. And in addition to the law, we had also adopted a lot of the UN conventions on the fighting of money laundering and financial crime and all those kind of things. So I would say that we do have a robust law on the subject. Perhaps the question, as Mr. Ayola has asked, is enforcement. And in the area of enforcement, I'm not sure. I think like lawyers will say, res ipsa locutor, the facts speak for themselves as to what is happening in relation to enforcement. And that perhaps may be what has led to this question. But in terms of the law, I think we do have robust laws. We have adopted the conventions on money laundering, and even beyond money laundering, even corruption and bribery and other financial crime, as far as the law is concerned. The question, I think, revolves around enforcement. And I will just leave it at that point, at this point for now. Yes.
But certainly it is a question worth investigating whether the Nigerian acts as drafted to what extent they cover the proceeds of acts committed outside the borders of Nigeria, and to what whether Nigeria has taken, for example, the Kenyan or the US approach, saying, yes, we target the proceeds of crimes committed abroad if they would be a crime in Nigeria, but only if they're a crime in the country where they're committed, or whether Nigeria takes the approach of South Africa or Uganda and says, if the act would be a crime if it were committed in Nigeria, then we are not concerned with whether or not the jurisdiction where the act was committed tolerates it or not. Now, as we saw, different jurisdictions, all in compliance with the international conventions, take different lines on this. I recommend the line taken by South Africa and Uganda, which unfortunately my own country does not take. So I want it to be very clear that I am not seeking to add myself to the long list of white Western experts that tell Africa how to do things. This is actually an area in which I think certain African countries, not all, I think Uganda's doing better than Kenya, where South Africa and Uganda are pointing the way, and I don't know whether Nigeria follows that approach, but I would certainly recommend it. As there aren't other questions, one thing I'll briefly touch on, which I didn't have time to in the presentation, is this all sounds very nice, but a pressing issue for Nigeria is do other jurisdictions that seize the proceeds of crimes committed in Nigeria, how willing are they to return the money to Nigeria? And the record of my own country, the UK, is not great on that. And Western governments and their advisors have been all too resistant, and they come up with excuses. And therefore, I would say that it is the responsibility of allies such as myself, such as Dr. Asquith, such as others, to continue to press on this. It's great that James Ibori had 50 million pounds of his ill-gotten assets removed from him, but I entirely agree with those that say that at least a significant proportion should have been returned to Nigeria, and they weren't.
Thank you so much. Thank you so much, Mr. Oyomi and Dr. Alexander. Thank you. I believe your question was, yes, do you want to say something?
Answer. Yeah. Well, I think there was a mention by Richard about the Ibori assets and about the returning of that money to Nigeria. I would say that a part of it, if not all, at least, has been returned or is on its way here. But what has now generated, or the debate now, is who is to get the money when it arrives in Nigeria? Is it the federal government, or is it the state from which the money was looted when he was governor? And there has been a whole lot of debate going on that. Some people speaking that it is for the federal government, and some people speaking that it is for the state. And that debate, I think, is still on and is not yet been resolved. The arguments of those who believe the money should go back to the state is that the money came from the state. For the federal government, there's this ingenious argument that the negotiations for the return of the money was between the federal government and the UK government. But of course, we know that the states can't negotiate directly with other nations. It's not a sovereign state. So it's a federal government that would negotiate on behalf of all the states, that anybody in this country. But like I said, the jury is still out. That's the argument. So the federal government has said, "Oh, we negotiated it. We entered into the agreement with the UK government, and as such, we're entitled to the money. And we have said we're going to use the money to build infrastructure and do a few things which will benefit the entire nation." But again, that depends on where that is located. But of course, the state is saying, no, that money belongs to us. It was taken from our purse, from our treasury, and it needs to be returned to us. I'll just stop here, and then we'll see what happens. Whether that again will go to the courts is for some who wait and see. But anyway, these are developing issues that we'll see as they develop and what kind of jurisprudence will develop out of that. Thank you. So Kike, back to you.
Yes, thank you very much, Mr. Yomi. Okay, there's another comment here. I'm not sure if it's a question. I'll just read it out. I'll be frank that this has exceeded my expectations. Honestly, didn't know what to expect when I registered to participate. Oh, wow. However, I've been enlightened a whole lot, especially with regard to genome editing. I would like to ruminate on this a little bit before revisiting the issues that have been debated in the public sphere for a few years, especially in agriculture. Okay, thank you very much for that comment, Chogu Ako. We appreciate it. This is a quarterly lecture series, so there's going to be another one in the next quarter. And so we're sure that you're going to have your mind blown every quarter if you attend this, this lecture. Thank you very much. So briefly, because we've overshot our time, we'll just take a brief appreciation now from the SOAS team before we close the event. Thank you, everyone.
Thanks, Kike. Yeah, just a very quick kind of thank you from us, really, and to all of you for joining us today. We really appreciate your time and your engagement in today's lectures, and thank you for all your questions. Thank you for everyone who's completed the poll. That will really help us to continuously improve these sessions as we go. And we're really looking forward to bringing you more lectures like this over the next quarter, as Kike mentioned. We will have more for you. So thank you all for joining this first lecture series. We really appreciate it. We will be holding more of an open day kind of session where you can hear more about the SOAS CEFIM's degree courses. You can ask us any questions specifically related to whichever course or courses you might be interested in. So we're looking to hold that on the 7th of August. So please do come and join us then, and we can tell you more about the programs that we're offering, and also how the Centre for Law and Business can provide that academic support to you that is vital and will really help you in your studies with us here at SOAS. So yeah, just a massive thank you from me, from Alberto and Richard, and thank you to our CLB colleagues for your help and support with this event as well. It's been really good, really eye-opening, as people seem to have found it really interesting. So yeah, I'm looking forward to more. And with that, I will say thank you and goodbye, and I'll hand back over to Dapo and Kike for any closing remarks from you guys.
Thank
Or
you.
in fact, anyone.
Okay. Kike, want me to do the closing remarks, or you will go?
You could go ahead, sir. Go ahead, please.
Okay. I reiterate my appreciation for everyone who has attended this program. First, again, let me thank the SOAS team, Richard, Alberto, John, and the others who are not here, Senia and Helen, who have worked with us at Center for Law and Business in putting this lecture together. And for us, the joy or the gratification is not necessarily from this first one, but the fact that it's going to be a regular series of public lectures. Is one of the things that you will say that it's the consequence or aftermath of COVID-19. In every situation, as I always say, there are advantages and there are disadvantages. One of the disadvantages of the present times is that virtual events have become quite popular, and they have become quite effective and very convenient for communication and for meetings of this nature to hold and at minimal cost. If we were to hold this physically, the entire SOAS team would have had to fly down, rent halls, accommodation, tickets, feeding, and all those kind of things. But all of that is not here now. And the lecture has been as effective as it would have been if it was physical. So that's one of the advantages of the present situation that we're taking advantage of. I want to thank the CLB team led by Kike in putting all of this together. Technology is a matter of the youth, and they have shown that they have a master of how to do technology. If this was left to me, I probably would still be floundering around as to what to do and how to go about it. To the audience, thank you. It's been a very rainy day for those who have joined from Lagos. For those who joined outside Lagos, I don't know what the weather situation would have been in your area, but we thank you all for joining us, reiterating what John has said. But I'd like us to focus on the future quarterly lectures and the opportunities that we can get from studying one of the MSc programs with Cephins, which is a center of SOAS. There are good programs, quality programs, MSc that will be useful, International Business Administration, Finance and Financial Law, Public Management, and Public Policy that are very useful and would help to put our society in good stead. So as John has said, there's going to be an open day later where we'll talk more about these programs and how admission can be obtained and the kind of support Center for Non-Business can offer people so that without relocating to London, they'll be able to obtain the very prestigious degrees of SOAS University of London and join the SOAS alumni and the University of London alumni. Let me end by saying once again, thank you to everybody. Thanks to the SOAS team, thanks to the CLB team, and thanks to everyone that has attended this program. We say thank you very much, and we hope that the future ones you would attend, you would let people see how beneficial it has been, and we'll allow you and say, please invite other people so that the word gets round and more people benefit from these programs. For me, an educated society is a better society. Where people don't know their own rights, then they certainly can know the rights of other people. And education is a very, very important tool in one knowing their rights and running a very just, fair, and equitable society. Thank you very much, everyone, and God bless.
Thank you, everyone.
So, Kike, the last word.
Well, I think you said it all. I mean, there's nothing more to say. Thank you, everyone. Thank you, SOAS. Thank you, CLB. Thank you, members of the audience. Thank you. And see you again at the next one. Bye.
Thank you. Bye-bye, everyone. Richard, Alberto, John, talk to you later in the week.
Thanks, everyone. We'll speak to you soon.
Sure. And regards to Seni and Helen as well.